Hello everyone, and welcome back to the Pro Bono Happy Hour. I'm David Lipscomb, Director of Strategic Communications for PBI. We've got a very special episode of the Pro Bono Happy Hour this week, in which our Law Firm Pro Bono project team talks about the Law Firm Pro Bono Challenge. If you're not familiar with the challenge, it's a simple pledge that asks law firms to dedicate either 3 or 5% of their billable hours each year to pro bono. Tammy Taylor, Rena Glazer, and Eva Richardson gathered recently to discuss the history of the challenge, its development and significance, and reasons your firm should consider becoming a signatory to the challenge. We hope you're comfortable wherever you may be, whether that's mid-commute, on your lunch break, or perhaps working at your desk and considering joining the challenge, and we hope you enjoy the episode.
Hi everyone, welcome to the Pro Bono Happy Hour. Thanks for joining us today. I'm Eva Richardson and I'm joined by Rena Glazer and Tammy Taylor this afternoon. We're here to talk about the Law Firm Pro Bono Project's Pro Bono Challenge. So we are going to be doing a bit of looking back and looking forward today, kind of taking a look at the history of the challenge and back when it first launched. We just celebrated the 20th anniversary of the Law Firm Pro Bono Challenge this past year, which we're super excited about. So that's what we'll be talking about today.
Challenge reports are due.
Yes,
So we thought we'd take a break from crunching numbers and corralling survey reports.
Great. So Tammy, we just wanted to kind of pick your brain on the launch of the challenge and its history, and go take a trip down memory lane with you. So.
It's a long memory lane.
So, Tammy, maybe we could start with your telling us a little bit about what the law firm and pro bono world was like then, and where were you? What were you doing?
Well, let's see. The Law Firm Challenge they started drafting it, and by they, it was a collection of law firm managing partners and corporate general counsel. They started drafting in 1992, I think it was, and it took a number of rewrites.
That's shocking with a bunch of lawyers. I am shocked. I'm glad we are sitting down for that. So let me take a step back. Before we get to drafting, someone or some group of people had this light bulb idea. Do you remember how that came about?
Wow. That maybe...
Was there a listening tour? When did that happen?
There was. And the Law Firm Project itself started in 1989, and it began with a listening tour. We did regional meetings in, I think it was 6 different regions of the country at that time. Might have been slightly less, but it was, really dredging here. A combination of Jack Martin, who was the general counsel at Ford at the time. I think, I can't even remember who might else have been. But it was managing partners of law firms. Jack Martin was certainly leading the charge. And basically it was a listening tour of a collection of managing partners in each region, and to find out what was going on and what they saw in pro bono in their firms, and how it could be made more relevant. At the time, pro bono has always been done in law firms, but it wasn't organized. It was ad hoc. There weren't professional positions for pro bono. There were a few firms who had pro bono departments, Hogan and Hartson as it was known at the time, Covington and Burling. They both had pro bono departments, but by and large firms didn't have specific people that you went to. And I think the listening tour was an effort to see what could be done to more formalize a pro bono structure in a law firm. And from that listening tour, the Law Firm Project was born. We created an advisory committee, and the advisory committee at the time was managing partners of major law firms throughout the country. And the challenge grew out of, I think, a desire to set goals, because we all know lawyers like goals and we like to achieve our goals. We like to strive toward something. And so the challenge, it was determined that a peer-to-peer challenge, rather than one that came from the project or from some outside organization, it needed to be a peer-to-peer challenge. And that stands true today. It's still a peer-to-peer challenge. As Rena said earlier, it took a tremendous amount of drafting to get the language right, to agree on the definition of pro bono. There was a lot of back and forth on that. They finally came to an agreement in late December, I think, of '92. And that was a very long time ago.
Well, I'll just throw in that I think it's interesting. This is where I think there can be some benefits to how, let's just say, to put it kindly, exacting lawyers can be, that we've had to do very little modifying.
That's true.
So all of that strategizing and crafting and being careful and being narrowly broad and broadly narrow was spot on in a way. You know, looking back now at you can't foresee everything, but you can come up with a document that will be a living, breathing, useful.
Reminds us of other documents, doesn't it?
Exactly. Exactly.
I think the thing, when the challenge was drafted, the one piece of it that maybe has warranted change over the years is that it was drafted with litigators in mind. It wasn't drafted with the idea that transactional non-litigators would participate in pro bono, because at the time there weren't as many. They weren't prominent in firms. Most of the firms who were anticipated to sign on to the challenge were litigation-based firms. And that's one piece where the definition of pro bono, or the idea of the challenge, I don't believe was as carefully crafted, just because that wasn't part of what the challenge.
The world
Right.
changed. The world changed.
And the world
Yeah.
has changed since then.
Yeah.
So that's the one place where we have made some changes to the challenge, or some broadening to incorporate some additional people.
Yeah, that's a great point.
So keeping going with the history, which seems rather tedious for some, but I keep finding exciting for some reason. I don't know why. For anyone who was privileged enough to meet him, John Pickering, who was one of the senior partners of Wilmer Cutler Pickering at the time, now Wilmer Hale, took great pride in tweaking the nose of Jim Jones, who was the managing partner of Arnold & Porter in '92, because the Law Firm project was housed at Arnold & Porter, and yet Mr. Pickering walked, as he put it, walked his firm's challenge signatory piece over to us at the project and beat out Arnold & Porter. He took great pride in that and told the story as many times as he possibly could. From there, we developed sort of our list of, I think it was the top 500 firms in the country. And we did an initial mailing in early January, trying to get as many what we called the charter signatories on. And they had to sign up by a certain date. I think it was early March. And then because of our connection with Mr. Pickering and his connection to Justice Brennan wrote a letter on our behalf to all of the managing partners in however many firms had not yet signed on to the challenge. And to me, that was actually one of the more exciting pieces of getting firms to sign on to the challenge is having someone of his stature participate and say that this was a worthwhile endeavor. I think that was terrific. So we continued to sign firms on until mid-April, I think it was, and then the challenge was officially launched on Law Day of 1993, and we launched at a local organization, N Street Village, and Attorney General Janet Reno was present, Justice Brennan came, John Pickering came. We had residents, women who were living at N Street Village. We had some other prominent lawyers from the DC area. It was truly a celebration and a great launching pad for the challenge. I think that looking back, I'm not sure anyone could have predicted the difference it has made, the excitement it has engendered, the copycats that are out there. And I would hope the pride that firms take in being part of this. Yeah.
That's amazing, and I'm sure that a lot of our listeners and even challenge signatories, because so much time has gone by and there's been generational shift, right, with people don't really know the origin story and how it came about, sort of the big boom. For people who may not be super duper familiar, let's talk a little bit about what the challenge is. What does it ask of firms, and what makes it different from other, sort of pro bono requirements or aspirational goals that may be out there? If you had to sort of, give the elevator speech of what's the challenge, what makes it different, how would you describe it to someone?
Well, I think first, it's a peer-to-peer challenge. We collect the data, but it's really your peer law firms who are asking you to be a part of this, be part of something larger than yourselves. It asks you as a firm to donate 3 or 5% of your total billable hours to pro bono each year, at least half of which should be to those individuals of low income or organizations serving them. It asks for a majority of the firm to participate. And the thing that has amused me and caused me angst all these years is the definition. It is a narrow definition. You have to perform legal services. And there are so many permutations of that. Who knew that I would actually be writing legislative history on this? I had no intention of doing that when the challenge started out. But boy, do we spend a lot of time on what counts questions. And just when I think we've probably answered the last possible one out there, someone comes in with something new and interesting and causes us to rethink how we're doing things and whether this new idea really is pro bono within the definition contained in the challenge. And I think that's really that narrow definition, I think, is what sets it apart. Because I think there are a lot of other aspirational goals out there, but that is a big piece of it.
I think at the time, if we take sort of the broad view of what was novel, I also think asking for an institutional commitment was new,
yes,
right? As opposed to in the profession where, and we've talked about this before, and I'm sure we'll talk about this on future episodes, and you can make all the lawyer jokes you want, but we really have a deep-seated ethos of pro bono. And it has largely been, though, person by person,
right,
lawyer by lawyer. And I think that reflects to the culture of the legal community that Tammy was talking about 20 years ago, where firms were doing amazing pro bono work, but it was very ad hoc. It was person by person, lawyer by
right,
lawyer, catch as catch can. each following his or her own passion without much infrastructure and without it being institutionalized. And that is not, at least for big law firms and large law firms, which is who the challenge is targeted for, right? In this peer-to-peer group, it's large law firms. That's not how they operate.
No.
And so meshing pro bono to how the firm is structured was really part of the genius of all of this, right? And kind of got us to where we are now as a pro bono community in terms of building deep roots, building infrastructure, building capacity, generating resources, thinking strategically, professionalizing, thinking about how you do your commercial work and translating those processes, procedures, standards of excellence over to sort of pro bono work, so they're of a piece. That it was so novel. I think we forget, right?
I do.
How truly innovative that was.
It's taking the pressure off the individual attorney to make it a part of his or her practice, and putting the pressure on the firm to create the structure and the support mechanisms, as Rena was saying, to do the pro bono.
Yeah, and saying it's part of the culture. Now, one thing you read or hear about when you think about the challenge is it's called progressive goals, the 3% or 5%. What can you remember, or do you sort of have ideas about the thinking of tying pro bono benchmarks to billable productivity?
Wow, I might have to think about that one. I think that there had been some studies done at the time showing that firms, the firms we thought might sign on to the challenge were already doing a significant amount of pro bono work. And rather than doing it by hours per attorney, which would penalize firms, and I'm trying to remember exactly how that all came down, but it came down to the idea that using a percentage mechanism for measuring the work wouldn't penalize anyone, because it wouldn't matter if you were a large firm or a small firm. Your goal would adjust to fit the size of your firm, and that was a more evenly based way to measure.
And proportional to productivity.
Right.
So it's sort of a living, breathing figure as opposed to a static number.
And it changes.
Yeah.
We've said for years that we don't report firms' individual performances in a disaggregated way, but I also don't look at a firm's individual year and determine that their program is not good or is terrific. I tend to look at a 3-year reporting scheme and see whether the firm has gone up, down, stayed the same, because I think that gives a better basis.
For sure. Do you have questions? I'm hogging Tammy, so.
Yeah, I guess just sort of big picture questions. What are some of the biggest changes you've seen in Law Firm Pro Bono since the challenge was implemented?
Oh, wow.
You talked about some already, but any other?
I would say probably the professionalization of pro bono. That has changed the landscape of how firms do their pro bono work. There is a single point person. I know when we started out, it's an interesting kind of combination, because at the time the challenge was promulgated, I was also placing death row cases, and I would have to call a firm, probably 10 or 15 people within each firm, trying to find someone who might be in charge of pro bono. And so, for me, in that particular position, it was, it just struck me as being, this is a colossal waste of time for the firm, for me, and if I'm just one program doing this, how many other programs are having to do this? So the change from that to the professionalization, the pro bono manager, counsel, partner positions that currently exist is huge. And I think has led to the ability of firms to expand their pro bono in unique ways to address the issues that we've got these days. It has led to the ability to include more people who wouldn't otherwise do pro bono. It's led to tying, as you said, Rena, tying pro bono more to commercial practice areas and using pro bono as a training mechanism. I think those are some of the bigger pieces that I've seen change.
Tammy, thank you for indulging me. I'm going to ask you to hop into the, hot tub time machine. And what were you thinking when it launched? Did you think, oh my God, this is a definite success? Or who knows? Or this is my job, so I'm going to try. Did you have any idea? Were you optimistic, pessimistic, or just sort of, I have no idea?
I think that given that my nature is more optimistic than not, I was optimistic it would be fine, and certainly there were many more learned persons out there whose idea it was, and I trusted them, I learned from them, and why not give it a shot? Why not see what happened? I think it wasn't just something they came up with overnight. They thought about it a long time. They certainly discussed it a considerable amount of time, and were very thoughtful about how it got put together. So, the logistics of doing it, we can always make something work. So why not give it a shot? See where we can go with it.
We've been spending a lot of time talking about original charter signatories and firms that have been part of the challenge for many decades. Maybe some of our listeners are thinking, well, is it locked and loaded? Is it too late? Are you accepting newcomers? Could my firm possibly join? Eva, Tammy, what's the answer to that?
If your firm has 50 or more attorneys, you're more than welcome to join. We would love to have you become a challenge signatory. We welcomed 2 new signatories this past year, and all you have to do is visit our website or reach out to us, and we have an enrollment form where you can pledge to do 3% or 5% of your billable hours as pro bono. And as we said, it's confidential. We never release your numbers, and there is a reporting requirement, but you have a grace period of a year when you join, so you can join at any time. You have some leeway there before you have to actually report to us.
So how burdensome is this reporting requirement? I could see being nervous and saying, I'm really busy and the people at my firm are really busy. What kind of burden is this going to be?
There are 3 required questions to the challenge survey every year. One is, what are your total pro bono hours? The second is, how many of those total pro bono hours were spent on work for those of limited means or organizations serving them? And then, how many people did you have in your firm? Partners, associates, counsel, staff attorneys. Those are the 3 required questions. Those shouldn't be that onerous. Nevertheless, we are here, and we are here to help you. If you don't have a way to track pro bono in the first place, if you don't have a way to track low-income pro bono, we will help you do that. And as Eva mentioned, there is a year grace period. We also, Eva mentioned that the goal of the challenge is not to embarrass a firm. We're not in the business to make you feel bad about how much pro bono you do or don't do. The goal is to do more, always to do more. And to whatever extent we can help you do that, we are here to do that. So, if there's some piece of the challenge reporting that you find problematic, give us a call, send us an email. We'll be happy to try and puzzle through it with you and figure out a good solution that works for you.
Any other reasons that we didn't hit on why you think a firm should join the challenge?
I think the stature involved in being a part of it. I think that People, and by people I mean those in the legal community, recognize that you're held to a certain standard of excellence if you are a challenge signatory. They know that you value pro bono, that your firm values it, that you will devote the resources necessary to achieve your goal, and that it's not just something you're doing to promote good citizenship, which is also a good thing, but not part of the challenge. It is just, it is a standard of excellence that is recognized.
And it being publicly visible is another kind of benefit of being a challenge signatory. We put out a challenge poster every year and we send it to law schools. And so law students can see that you're a challenge signatory, and it makes you that much more appealing to summer associate or recruiting summer associates, and it's another benefit.
Yeah, exactly. And there's more information on our website.
Yes.
So,
Yes.
yeah.
Your corporate clients really like it too.
Yeah, and get out ahead of it, because we have a corporate challenge for in-house legal departments, and one of the questions or one of the aspects to it is to ask their outside counsel to be signatories to the Law Firm Pro Bono Challenge. So when you are asked, you can already say yes, and it's one less hoop to try and jump through.
It is a done deal then.
Yeah, exactly. We do have an anniversary microsite on our website. It's really fantastic. People did a great job developing it this year, with historical information about the challenge, an anthology and compendium of all the challenge reports, so you could see how things have changed over time, celebratory pictures and videos that signatories sent us that just are a drop in the bucket of the impact that our collective pro bono efforts have had. So it's been an exciting year for us. We're not about to let it go too soon and turn the page, but it's been wonderful to look back, and it's exciting to look ahead.
The creativity of law firms is just astounding, and the microsite contains just a small nugget of what we've seen, and it is exciting to see.
Yeah, and it's something I think about a lot, because as Tammy talked about, it's sort of easy or conceivable to bog down in the weeds, right? The what counts questions, hours over hours, what does it all mean? And I think goes without saying that it's crucial to remember that the challenge and all of what we do is about the work and the impact on our clients. And the true measure of the challenge's impact is its capacity to improve lives and to serve those who seek justice. So I think standing true and remembering our core purpose is always useful, especially when we're talking about the tools to make that happen, that they are tools to the greater good.
Yes.
Great. Well, thank you everyone for joining us today on the Pro Bono Happy Hour. It's been a pleasure.
Happy anniversary.
Yes, happy anniversary.
Thanks for listening, and we hope some of you have been inspired to sign your firm up for the Law Firm Pro Bono Challenge. For more information, visit www.probonoinst.org/projects. You'll find information about the challenge by clicking on the link for the Law Firm Pro Bono project. To listen to more podcasts in this series or learn about additional pro bono resources, visit www.probonoinst.org/podcast. If you're interested in having your firm featured on the Pro Bono Happy Hour, please email us at probono@probonoinst.org. Thanks again for joining us, and we'll see you next time on the Pro Bono Happy Hour.